Welcome, everyone. I'm Maria Volpe. I'm a professor at John Jay College of Criminal Justice at the City University of New York. This is our monthly breakfast meeting. I started these after 9/11 for conflict resolvers, and we used to meet in person every first Thursday of the month at John Jay College. Since April of 2020, we have been meeting virtually, so welcome everyone who's able to join us from wherever you are in the world. These sessions are recorded. They are posted each month at the ACR-GNY website. That's www.acr-gny.org. We would not be able to do these breakfasts each month if it wasn't for this wonderful team that I'm a part of: Julie Denny, Chuck Newman, Matthew Latimer, and Nikki Borofsky. It really does take a village every month for us to pull off these wonderful breakfasts. Today is number 245. We've held that many breakfasts since 9/11. And we are so fortunate today to have with us a wonderful colleague, Bob Kim, and he will be introduced in a minute, to talk about a most timely topic for us. It just so happened that today is a memorable day, but we planned this breakfast some time ago and realized that here we are holding a breakfast on a topic that will be talked about all day today. Before I turn this over to Julie, who will more formally introduce Bob, I am going to ask Genesis to welcome us on behalf of ACR-GNY. Genesis is the current president. Genesis?
Thank you so much, Maria, and it's so great to be here. So great to be with everyone this morning. Thank you for giving me an opportunity to do a quick pitch for ACR-GNY. So we've been around for 20 years, and we've evolved to serve the greater New York conflict resolution community. A special thank you to the organizers of this event, Professor Volpe, Julie Denny, who's a past president of ACR-GNY, Chuck Newman, Matthew Latimer, and Nick Borofsky, and the entire John Jay College ADR program. Since the start of the pandemic, we've been working hard in ACR-GNY to provide ongoing member and community engagement throughout. And part of that is that we've actually doubled our programming since in the last 2 years. And so there are more virtual opportunities now to connect. We have our annual meeting coming up this month. We have our conferences in the summer. We also have practice groups. We have 2 different practice groups. One is commercial and employment. The other is community and family. And they provide confidential learning spaces where people can come together and share kind of like puzzling moments and get honest feedback. We also have Mediation Settlement Day, which is a celebratory event held each year to recognize and promote mediation. We also created last year the Student Ambassador position, which enables students to work closely with board members while receiving mentoring and support. We've also added new panels and presentations to help support skills building in our community, including a panel that we had last year on what bystanders can do when they witness behavior that makes people feel unsafe. And we also last year adopted a speaker diversity policy to ensure that a range of perspectives are offered at each of our events. And members obviously get access to all of that in addition to being listed as a practitioner on our website, being invited to special members only events, getting discounts. And we strongly encourage you to become a member of ACR-GNY if you haven't already. And just a note that for the first time in about 10 years, we're actually raising the rates for membership. So the rates have been $50 for, I think, about 10 years, and we're raising it to $95 a year. And so that goes into effect on February 1st. And so if you're not a member, please become a member now. And if you are a member, definitely, go in there and renew. And we hope to see you at more events. And I will put a link to become a member in the chat.
It's already there. Nikki's
okay.
Nikki's
Great.
Doing it. Yeah.
Nikki's amazing.
And the membership is $50 until February 1st. So if you were thinking about it, jump in.
Yes. Oh, let me just add one more thing, which is that we've also been working really hard to increase the amount of virtual content we offer our members on the website. So many of you may know that these breakfasts are now on a website available to everyone, but we just uploaded the 2020 conference videos on the website just for members, and we'll be uploading the 2021 videos for everybody pretty soon too, for the members. Thank you.
Thank you, Genesis. As many of you know, when we held these breakfasts in person, they've always been free, but the coffee and the bagels were part of ACR-GNY's contribution. So
And the fruit garnish.
Fruit garnish. Thank you. And now I'm going to turn this over to Julie, who will introduce Bob. Julie.
We are so happy to have Bob Kim here today to talk about what has become a very important issue lately. Bob is a writer, a consultant, and he's an expert on education law and policy in the United States. He's a former civil rights attorney. He's a writer who's written many books, articles, and columns, but his most recent book is Elevating Equity and Justice, 10 U.S. Supreme Court Cases Every Teacher Should Know. He's also served in multiple government roles. He was in the Obama administration as Deputy Assistant Secretary in the U.S. Department of Education Office for Civil Rights. And he was the William T. Grant Distinguished Fellow at Rutgers, where he taught education law and conducted research on school finance and education equity in U.S. public schools, and a senior investigator at John Jay College of Criminal Justice, where he investigated incidents related to Title IX and other forms of harassment and discrimination. He's well qualified to cover the issue that's of importance to us all. So Bob, take it over.
Thank you so much, Julie, and thank you everyone for being here. And a quick also word of thanks to Maria and Chuck and Nikki and Genesis and others for hosting this and for inviting me to come here this morning. I really find it kind of poignant and interesting that we're having this discussion about speech on the anniversary of the attacks at the US Capitol before the inauguration a year ago, exactly a year ago today. And so forgive me if I start to wax sentimental and start opining about democracy during this session, but you know, as I was preparing for this talk, that's where my mind went a little bit. So I do think that talking to you all, and in light of what you do as people who engage in mediation, conflict resolution, who are really navigating difficult conversations and facilitating resolutions in difficult situations, you do something in a way that is so essential to democracy. And I think I keep that at the forefront of my mind as I sort of deliver these remarks today. It also occurs to me that you come from so many different walks of life, from different regions around the country and around the world, and have a lot of knowledge already about law, about history, about politics. And so it's challenging, I think, for someone like me to add some minimal insights to what you already have learned and acquired over the years, but I will do my best to add to discussion and knowledge for this group. Let me see if I can turn on my screen here so that we can all be with each other on my PowerPoint here. So today we're going to talk about the boundary between protected and unprotected speech Started out my career as an ACLU attorney in about 25 years ago, actually, already. And if some of you are thinking, well, that means you became an attorney when you were about 12 or 13 years old, that's exactly correct. That's what happened. I wanted to reflect on some of the cases and issues that I worked on around free speech and bring that into the conversation, or just to share a little personal history and background with you. I grew up, and I swear this is going somewhere, I grew up in pretty far from New York City, actually in New Jersey, in a small town called Basking Ridge. And as you can imagine, if you're quite far from New York City in the suburbs and more rural parts of the state, it was fairly politically conservative, I would say. I grew up in an immigrant household. I'm first generation. My parents immigrated from Korea in the mid-1960s. We were a Catholic family. I grew up very religious and went to church every Sunday, and many times more than Sunday. I grew up and we were culturally conservative. The family was politically conservative, and also had these religious sort of roots. Now, the church we went to was called Our Lady of Perpetual Help Church in the town right next door. And fast forward many years after law school, I moved to San Francisco and became a gay rights attorney. And so, and started working on some leading gay rights cases, testing sort of what the rights are and what the rights should be in the United States around LGBTQ+ rights. So automatically, just to pause here, you can imagine the conflicts and the need for resolution that occurred within my own family. And I probably could have sought the counsel of many of you back in that time. Let's leave that aside for now. But one of my first clients, and remember, I grew up in this church called Our Lady of Perpetual Help. One of my first clients was a group called the Sisters of Perpetual Indulgence. They were not a religious group per se, but they were a very colorful group of drag queens and trans activists who were fighting for civil rights, and they were critical in many ways of the Catholic Church. And one of my first tasks was to defend their right to demonstrate and to give performances and presentations on Easter Sunday in the middle of San Francisco in a public park. And the city of San Francisco was threatening to withdraw or remove their permit, taking away their right to demonstrate and speak on Easter Sunday about their criticism of the church and their espousal of gay rights and queer rights for people of all different stripes. So, it was an interesting experience to represent that group. They were undoubtedly inflammatory and colorful in their presentation in some ways, but they also had a point of view that was very important and that we thought was important to protect in terms of their right to speak out. Now, as I became an ACLU, an attorney sort of working on other issues around LGBTQ rights, the First Amendment really became inextricable from that docket that I worked on. I worked on cases involving bullying in public schools, in which, and this was right around the time of Columbine, when schools and communities were getting very nervous about safety and gun violence in schools. but we were, I remember representing somebody talking about how upset he was that he was being bullied for being gender nonconforming, and he blurted out in the cafeteria that he's so upset about what was happening to him, he wished he could shoot somebody. And of course, the whole disciplinary process happened to him, and we were called in to try to represent his views and place into context the speech that he had uttered in the cafeteria, and that he should not be disciplined for saying that. Now, we might have a different sensibility around somebody saying that he wished he could shoot someone in a public setting like a school today, given what has happened around school shootings around the country. But at the time, it was very unclear, and there was more of a sense that the school should really be more understanding of the speech that boy had committed. Another thing to be aware of at the time around LGBT rights was the rights of teachers to say that they were gay and to come out in public school settings, and the right of trans teachers to actually exist and be teachers and not be fired for who they were. Back then, again, this was 25 years ago, there was less of it was less of an employment discrimination matter for these teachers. We were, because those rights had not been hadn't matured yet, as we do recognize that they are today. But we were talking about gay rights and the rights of trans educators in terms of First Amendment rights, that they had a right to express themselves and to appear and say things about their identities and to be who they are as a matter of free speech and free expression. So those were very formative types of cases for me in the context of LGBT rights, and it sort of cemented in my mind and increased my own awareness of First Amendment rights in the United States as really developing and being bound up in the rights of disenfranchised populations. In other countries around the world, we know that free speech has developed from the ancient Greeks, across the pond, from John Milton and other principles around the right to have a degree of freedom to say what we want. But in the US, as I reflect upon my career so far, it does appear that that the genesis of free speech has really come from the struggle for equality among disenfranchised populations, whether that's people of color, religious minorities, LGBTQ+ persons, and so forth. The other couple of things that I'd like to sort of just put out there, as we get started, and these are more recent events in my career. You will all recall in the United States how there have been demonstrations around Black Lives Matter, and the huge numbers of people who participated in parades and really were wanting and yearning for a way to express themselves after the deaths of George Floyd and Breonna Taylor and so many others. And there was this real outpouring of speech on the streets last year and the year prior to that. Now, I worked at John Jay College with Maria, and I don't know if anyone else is on the call from John Jay, but the interesting way in which speech became a part of my job as a compliance officer at John Jay was that people really wanted to talk about sort of what was going on around racial justice and the actions of the police in academic settings. And there were also people who really were against Black Lives Matter and were against the notion that there was something wrong about the way the police were acting all around the country, both now and historically. And so, as you can imagine, that led to a lot of interesting and uncomfortable situations and conversations in different classrooms and around the campuses. And that became a real issue and challenge, I think, as a matter of running an institution, how to allow for disagreements and very and really upset feelings in classrooms, in and out of classrooms, how to allow for that while also acknowledging that many students of color were very upset and were experiencing trauma around what had happened to them in their own lives, and also what they were experiencing in classrooms because of the speech of others. And so, we really did, I think, at John Jay and in colleges around the country, really need to find alternative ways to resolve these disagreements and upset feelings between students and others without resorting to discipline and then the compliance apparatus, of the institution. So, that was one signal and reminder that speech is very important to protect in these settings, but we also need ways to resolve conflicts and disagreement in a non-punitive, non-disciplinary way. And then the final thing, I guess I'll say by way of this sort of long introduction into our topic is the issue of critical race theory. It struck me in preparing for these remarks that we have, at least in education circles around the country, this proliferation of laws around the country trying and purporting to squelch or censor discussion of important topics around racism and sexism in public education around the nation. And without getting too political, these stem from earlier efforts in the Trump administration here in the United States to do the very same thing by way of federal executive order to disallow conversations where disallow curriculum and training around issues of racism and sexism in order to prevent any students from feeling targeted or blamed for historical racism and sexism. And so there is that issue is also at the top of our minds and is really, especially in the K-12 setting, a real source of political tension and upset in many communities and school systems around the country. And so, this is really, this topic around speech is so timely. It's on the one hand, we have those who want to deny speech and to prevent speech from happening around topics around racism. And on the other hand, we have people who want to punish those who say offensive or uncomfortable things around race or racism. And so, one of the messages I think is that, and the difficulties here in navigating this space is that it's really hard to squelch or to censor these types of speech without affecting all kinds of discourse and learning. And so the hard situations really is what we really want to talk about and lean into in this conversation today. There's really nothing that there's no disagreement that in most kinds of speech that there's, or let me start over here and just say that it's really, in many areas there are things that we have no disagreement around. If you talk about injuring somebody, we all realize that that is unprotected speech, that there needs to be some kind of sanction for that. On the other hand, if you are talking about a whole range of different topics around art or around science or giving an opinion that is purely personal in nature, that there's really little disagreement about that either. It's obviously protected speech, but there are more difficult situations that emerge that are kind of this gray area. And I think that's what we want to do and explore a little bit today, and what I'd like to explore with you today. So the goals of what I'm going to talk about today, and I think it'd be optimistic to even get through a lot of this, most of this, but let's see how well we do today. I'm going to sort of move forward a little bit here in my talks, but we want to kind of understand and just get a little bit of grounding on how law and policies help to inform speech. And I lean a little bit heavily, because it's my own background, on United States law, but I sort of put that plus here because many of our we have folks from around different countries around the world, and certainly some of the United States principles and holdings in the law apply or are similar to the laws and policies in other countries around the world. So it'll be primarily United States focused and focused around the First Amendment, but let's see how applicable. I think there's generally applicable principles that apply to other countries as well. We want to do a little bit of work to distinguish between protected and unprotected speech as informed by these laws and policies and principles. And hopefully we can just share a little bit about and present a few ideas about strategies and actions that could help us as mediators, those who are engaged in conflict resolution, to really prepare for and manage situations involving uncomfortable yet protected speech. And the important question I think I want to raise for us all today is why might it be important to preserve a space for conflict and disagreement? It's a little bit of an interesting way to pose a question for this group, because I think a lot of us are working to resolve conflicts and disagreements, but it really, I think I would posit, it's important for us to for there to be a space for conflict and disagreement. This is an important part of democracy. And if there is no conflict, then, maybe there are other things going on that are undesirable, that in our society that we ought to avoid. And so, certainly as we're talking here on the anniversary of the attacks or insurrection, the events in Washington, D.C. a year ago, I think it really is important and worth reflecting on why conflict and disagreement not only is not a bad thing, but it's actually something that is important and necessary in a healthy functioning democracy. And certainly the question is for us today, and especially for this group and the work that you do, what's our role in preserving this space, and certainly in helping to make that space productive and useful in all different contexts, whether I know you work in many different areas, whether it's in education or in other areas of law or in for other institutions, and many different kinds of institutions. So, just to get started around defining the idea of societies that are protected versus unprotected. Some of you may know this controversy here. Who is this person, Peng Shuai? some of you may follow sports, and I particularly enjoy following professional tennis. This is someone, as you may have heard in the news, who is a professional athlete, tennis athlete in China. She was voicing she was basically came out about a month ago, maybe a little over a month ago, and revealed on Twitter that she was sexually assaulted by a high-ranking member of the Communist Party in China. And shortly thereafter, she disappeared. All accounts of her social media accounts were disappeared. Nobody could tell whether she was alive or dead. She basically was removed herself or was removed from the visible world. And so, it resulted in a lot of media attention. Certainly one of the first times ever that a citizen in China had engaged in a Me Too type of allegation against a high-ranking government official in China. So all kinds of things happened to her. So I raised this, as one example of somebody who who's living in a system, and I'm not an expert on any kind of speech issues around China, but it seems clear that in that government system and in that country, there is a severe and strict limitation on speech that is allowable, and that many, or if not most kinds of speech, especially those that are critical of the government, are disallowed and are not protected by any kind of law. Now, on the other hand, in juxtaposition to sort of the world, at least portrayed to the Western world around what's around speech rights in China, then there are sort of this whole other opposing world where there's a lot of free reign, anarchy, chaos. All conversations can happen, and there's really nothing that is not protected speech. In other societies, we may, I don't know what society this is. Some people may think this is the United States around, especially on the internet these days and in social media. It seems like almost anything goes. And so there can be a very, very wide range of offensive comments and critical comments about people and all kinds of things happening. And this alternate world is one that we would say where almost everything is protected speech and very little, or maybe too little, is being regulated or restrained in any type of way. And so the way I like to think about this is that we have societies and countries around the world where these two realms of protected speech and unprotected speech. And in some countries, the amount of speech that is protected is greater, in the green there, and in other countries, there's less that's protected and more that is censored or stopped, and that would be in the red. And so for me, what's interesting is the space in the middle, that sort of orange space. There's a lot of speech that exists in countries and in our world that's very uncomfortable. It's inflammatory, it's disrespectful, offensive, very provocative, and even scary in some ways. And for me, this interstitial space, the interstices there between protected and unprotected speech, if you will, that's kind of where all the action is. That's where we are. That's why we, those of us that are administrators and those of us that deal with conflict, that's where all the action is. And as I mentioned in the beginning, for me, preserving this interstitial space, and in particular, making sure that this space is in the green categories, protected, is really essential to democracy. We need there to be some room for disagreement and for discomfort, and that may be deeply uncomfortable and upsetting to folks, and certainly in a mature democracy we also need for some of that uncomfortable or inflammatory speech, if it's uncomfortable or inflammatory enough to the point that it goes to a level that should not be protected. In a mature democracy, there's also, some of that speech, a percentage of it, will also and ought to be unprotected, and be subject to some kind of sanction as well. But really, I think, we really need for a lot of that interstitial speech to be protected. Okay, so this is the element here. We really have to decide and need to be aware that that some of this speech should be protected and some of this perhaps should not be. And where that line is going to be different in different countries, in different settings, but that, putting out there, can we agree that much of this should be in the green, and perhaps some of this should be in the red as well. Now, speech in the United States takes many forms, and just as a as a way of establishing what we mean by speech here, we're talking about all these things on the page. It's not just spoken words and what people say to each other in verbal format, but it's many, many different kinds of behaviors, how we appear, what organizations we join, what we write about, and it can include just about any mode of communication. So as a way to just establish what we're talking about here today, we really are talking about all of these things, not just verbal back and forth between people. Now, in the United States and around the world, actually, I altered this just so we can get a little bit international here. I wanted to sort of frame how speech is regulated or protected in different countries around the world. I think of speech regulation as involving three primary levels. Maybe you guys would slice this a little bit differently, but when I think of how speech is regulated, I think of different laws that apply, whether it's from international law or agreements or declarations. And then certainly within nations, there are a host of an interplay between federal, state, or provincial and local laws and ordinances that can affect what can be said or not said in that society. And there are different forms of law as well that inform how speech is regulated. We know that there's legislation or statutes and regulations. There's certainly executive orders, witness the President Trump order on critical race theory in 2020. There are court rulings, and we'll quickly talk about some Supreme Court precedents in the United States that affect speech. And then, of course, and there are other kinds of laws. So maybe contracts employment contracts, for example, could affect how speech is regulated or protected. Now, in the United States, at least, for the federal Constitution, the US Constitution, speech is regulated only among public entities. So what government officials can say, what public employees can say or do, or restrict folks, is what the US Constitution is concerned with. But a lot of these laws, and maybe in laws around the other parts of the world, private actors, private entities can also be regulated in terms of what speech is allowed or not allowed. So laws can apply to both public and private actors. When we're talking about the US Constitution, we are talking about, in the First Amendment, we are talking about the regulation of public entities only, not private ones. Then there's also other layers that we want to remember, that it's not just laws that affect how we behave and what speech is allowed in different settings, but there's also another layer of policies where, if we're talking about companies, we're talking about universities or public school systems, we're talking about ways that different types of professionals speak, lawyers or medical professionals, they're all governed by standards of behavior, by policies, even by some requirements associated with being a member of that profession, that also might regulate or have something to say about what kind of speech is allowable or not for those individuals. And then, of course, individual behaviors or practices, regardless of laws or policies that might be on the books or apply to any individual, there's this whole realm of how people behave and what the practices are in different communities that really largely, it's kind of like the silent law. It's speech can be regulated just by the way people behave, whether or not they're adhering to a law or any particular policy. So, just a little bit of framing about how speech is regulated or protected is the point of this part of the conversation. And then going quickly to the United States context and the First Amendment, some basic concepts here that may be worth just putting out there for us to consider. As we all know, the United States has the First Amendment, which says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or the right of people to assemble, or freedom of the press. So this is where the freedom of speech protection in the United States at least comes from. And there are a couple of basic concepts that apply when we talk about the First Amendment and what the protection is around free speech. And I'll just quickly go over 3 tenets that are fairly clear when you look at some of the case law and what governments, including public school employees and other public employees, should abide by. Number 1 is that government can't or really should avoid regulating or overly restricting the content of speech. And we'll go over some of the exceptions in just a minute. Governments can regulate in some ways when people can speak, or where or how they can speak, in terms of some restrictions on, just to maintain order. For example, you can speak in this area of a campus between 9 a.m. and 5 p.m. You may not use amplifying devices during that time. You can only speak in a way that makes it easy for faculty and classes to exist. You can't disturb what's going on in that particular location. That's a time, place, and manner restriction. That's probably okay. But in general, the government should avoid restricting content of speech. Even worse than content restrictions are viewpoint types of viewpoint discrimination. And by that, we mean, even if the government can say, okay, no political discussion in classrooms that don't relate to that express curriculum in that class, even if we were to allow that kind of content restriction, we can't say that particular types of viewpoints, political types of particular types of political arguments are allowed and others are not. That's a viewpoint restriction, which is even more sort of verboten in the eyes of the law in the United States than content restrictions. And then certainly you can't place restrictions on speech that are overly broad or vague. These are subject to challenge or being struck down. So, you know, public entities can't say that citizens should not engage in conversation that is, for example, annoying or disturbing. You know, that kind of those kinds of adjectives might be considered overly broad and vague and capture a lot of speech that really should be protected. So, so those kinds of restrictions on speech are usually not allowed as well. So those are some basic sort of tenets, I guess, or concepts around the First Amendment and how speech is regulated, what's allowable. And if we just sort of look at some of the case law, and I'm cognizant of time here, I want to make sure that we have time for questions and some discussion. There are a couple, at least in the US education context. Now, I know many of us don't work in education. That is my particular area of concentration. I do still think that some of these cases that deal with education are helpful for us all to think about in terms of defining protected versus unprotected speech. Certainly some of the principles in these cases do apply outside of the education realm. But if I were to sort of point out just a few cases worth dwelling on in terms of the way that they help us define what is protected speech in the United States, I would point to, for example, the Tinker case, where this was a case, as many of you recall, during the Vietnam War era, where students were disciplined for wearing black armbands on their black armbands to protest the Vietnam War. They were threatened with suspension, or they were actually suspended from school for wearing these black armbands to protest the Vietnam War. And the Supreme Court held that under the First Amendment, public schools can't prohibit student speech unless it would, quote, materially or substantially interfere with school or government operations. And so that's a pretty high bar that sort of basically stands for the premise that a lot of uncomfortable, ridiculous, offensive, and even offensive types of speech must be allowed to, must not be censored, must be allowed, unless it would really reach that point where that speech is materially and substantially interfering with the operations of that institution or that school. And of course, this applies to public schools only. So that's one sort of clue about what's protected versus not, and sort of gives you an automatic sense of how much speech actually is protected, because it's a fairly high standard to achieve to before we get to this threshold that we can talk about censoring or punishing or disciplining somebody for what they say. Another, you know, that whole Tinker standard was reaffirmed essentially just last year by the Mahanoy case by the US Supreme Court. And many of you will have remembered this because it was very recent, but this was a case involving a 14-year-old student named Brandy Levi, who was suspended, who was suspended from her high school cheerleading team for essentially posting on her private social media Snapchat account kind of a profanity-laced criticism of her high school softball, or her high school extracurricular team and the coach. And this was completely on her own time, on her own social media account. And the government and the school basically kicked her off of the cheerleading team because of this speech that she uttered on her own Snapchat account during her own time. And the Supreme Court basically upheld the student's First Amendment rights there and said the school shouldn't have disciplined her, but it also affirmed that off-campus speech could, in some situations, be regulated by public schools. For example, if, back to Tinker, if that speech were materially or substantially interfering with something with the school, which it did not in this case in Mahanoy, if there was some kind of severe bullying or threatening behavior that was part of that off-campus speech, it could also be regulated by the school or be subject to discipline. The student could be subject to discipline. So Mahanoy was kind of in some ways a reaffirmation of Tinker as applied to off-campus speech. And so I think it's interesting in other contexts where we think about employees saying things outside of work or other examples of sort of speech that's uttered privately in settings away from the institutional setting. Mahanoy stands for the principle that though that kind of speech isn't totally off limits from governmental scrutiny, but at the same time, it should be accorded more deference than, and there should be more freedom accorded to that type of speech than speech that's uttered on site or within the confines of a school or a workplace setting and so forth. And then two other cases I want to mention really quickly. The Pickering case, this involves employee speech, and it sort of stands for the proposition that this was involving a school teacher that was fired for being critical of the school in her local newspaper. And the Supreme Court held, and this is probably the high water mark or point, as many of you know, late 60s for employee free speech. But for the Supreme Court basically said that for matters of public concern or matters of public importance, that the government employee, the teacher, should be allowed to say what he wanted in that case, especially absent proof that the teacher was making sort of a reckless and false statement about the school. That unless that were happening, that on matters of public importance, the speech should be allowed. And then finally, one other case that I thought was kind of relevant that I wanted to share with you is this case, the Rosenberger case involving the University of Virginia, where the university had denied a religious student club with funding due to its objection to the religious views expressed by that club. And the Supreme Court held that that was wrong, that it was viewpoint discrimination. And really what was interesting about that case was that the Supreme Court was sort of establishing that there are different kinds of forums that the government sets up in which speech can be more or less regulated depending on the kind of forum. So in one sense, in a purely private forum, let's say if you're in a school setting, a faculty meeting, there's no sort of sense necessarily of free speech in a private meeting. Actually, I don't know if faculty meeting is the perfect example for a private meeting with no free speech rights, but for purposes of this conversation, we'll say that in private meetings would be considered a private forum where free speech rights do not are not available. And then on the opposite side of the spectrum there in terms of forum, there's a completely public forum like the town square, the sidewalk on the street, where there's just no ability of the government to regulate or suppress speech, or very little, because it's a purely public forum that where the government cannot reach and sort of dictate what can be said or not said. And then in the middle there's this kind of limited public forum, which in which the government establishes a space for people to speak. This could be a club, this could be a extracurricular life or clubs. This could be a space for student works of art. It could be a government listserv, for example. such as the one that is established by John Jay for this group. You know, these are sort of limited public forums, and the Supreme Court is saying in Rosenberger that once there's a limited forum is open, the state has to respect the boundaries that it itself has set in that limited public forum. So some content boundaries are okay in a limited public forum. For example, if it's dedicated to talking about music and art, then it's okay to disallow conversation around something that has nothing to do with music or art. But even in this limited public forum, the Supreme Court is saying you can't sort of discriminate and suppress speech based on the viewpoints of that accepted topic or that defined topic within that limited public forum. So I think that that's useful to this case in sort of defining for us different types of forums that are established in society, from purely public to purely private, and then something in between. And depending on the forum, you can either, speech is more or less protected. Now, speech that's not protected in US law, at least, include those that are types of speech that are listed on this slide. And I guess, you know, we won't go through all of these, but I will just say, you know, maybe sort of, you know, you can sort of see the other ones that are clearly sort of out of bounds, let's say, for something that, you know, you won't be saved by the First Amendment if you engage in one of these types of speech. The one that I'll sort of focus on, because this is something that many of us are involved with, is when people are engaging in very aggressive kinds of speech, not just offensive speech, but very aggressive types of speech that do constitute types of offenses that have been held to be outside of the protection of the First Amendment. And one of the types of speech there that is on many of our minds, many of those that sort of work in these institutions, is harassment at the bottom, because that is a type of speech that has been held in many contexts to be outside of First Amendment protection. So I want to dwell on harassment for a second, just for the sake of time here, not go over the other ones, because that's something that many of us are engaged with in our line of work. So the US case that I think of in education, at least, where that sort of defines harassment or helps us to understand what harassment is the Davis versus Monroe County case. This involves a 5th grade student who was targeted in a sexually suggestive way by a male student, and in a way that really impacted her ability to learn. And the Supreme Court held that under Title IX, that schools can be liable for this harassment of at the hands of one student against another, if that harassment is so severe and pervasive and objectively offensive that it affected and effectively barred that student's ability to learn in school. So there's this severe, pervasive, and objectively offensive test that was set up by, established by, and sort of articulated by the Supreme Court in this particular sexual harassment case. And so you'll automatically see that there's a lot of speech that students engage with in that does not rise to this level. That's not severe, pervasive, and objectively offensive. That is annoying, certainly upsetting, but not so severe and pervasive and offensive that it denies a student the ability to learn and to access her education. So that's a fairly high bar that was established by the Supreme Court for what speech might be constituting harassment and fall outside of the protection of the First Amendment. And then to juxtapose that with other types of law, in the US at least, we have the Equal Employment Opportunity Commission sort of also defining harassment in the employment context somewhat more broadly, as you will see, than the Supreme Court. It's unwelcome conduct based on a protected category, but it's harassment is unlawful where, and you'll see, it's either it's offensive conduct that's a condition that becomes a condition of continued employment, or the conduct is severe, pervasive enough to create a workplace that's intimidating, hostile, or abusive. You know, this language is very familiar to many of you. So that is somewhat, you'll see some of the adjectives there are similar to Davis, the Davis case in the education context, but it's also perhaps in some ways a little bit broader. So that's how the US EEOC is defining what is harassment, unprotected speech in the employment context. Now, juxtaposing that one more time with institutional policies, and we can sort of talk about this in you know, if it's interesting to folks, but you know, I used to work at CUNY and John Jay College, and CUNY's definition of unprotected harassment, unprotected speech that forms harassment is, you know, kind of similar to that EEOC definition of harassment in some ways, but it also mentions that, you know, even speech that has the purpose or effect of interfering with a student's or an employee's life, work or academic life, or creates an intimidating, hostile, or abusive environment, that any of those things could also be considered harassment and unprotected. So, you know, especially the word effect has a way of considerably broadening what harassment could be, not sort of the intentional, severe, pervasive, unprotected, and offensive behavior, but also if it's perceived or the effect of it is creating this type of environment or this result for a victim of that speech, that would be unprotected as well and be considered harassment. So a little bit broader, I think, than sort of some of the language in the courts, at least in the federal courts. I won't go over this, but we'll see that there's lots of examples of what would be unprotected speech at CUNY. And so certainly, as by way of summary, there is a lot of speech that we would consider, many of us would consider deeply troubling, that is uncomfortable, deeply offensive, disturbing, yet protected. So, you know, as you can see, we're sort of getting to this, you know, cementing this understanding of this space, this interstitial space that causes a lot of problems and yet is protected. And so we want to grapple with that a little bit. Now, in terms of strategies, I think, you know, I would pose for you, and then I'd love to hear, you know, your comments or your ideas. I think of strategies to deal with this uncomfortable yet protected speech. I think of it in two kinds of ways. One is at the institutional level, and secondly, at the individual level. And, you know, I would say for those of us that work in institutions and are trying to deal with and resolve conflicts and disagreements involving uncomfortable yet protected speech, you know, there's some value in, for sure, creating language, policies that clearly delineate what is protected versus unprotected conduct in those forums or in those institutions, so that the rules of the road are clear. So in some cases, they're not so well defined and there aren't clear examples, and so it doesn't provide good guidance for students or employees or other actors within that system of what they can do or not do. But then beyond policies, you know, creating initiatives and forums to really help actors within that space to engage and to have safe forums where they can disagree, where they can learn from each other and so forth. That's clearly the mission of many universities and educational institutions, but even outside of education, considering different initiatives where there are opportunities to increase engagement and respect for speech of different kinds and for viewpoints that are very diverse from, depending on who the speaker is. And then certainly, relevant to what you all do, and this became clear to us at CUNY, it's so important because there are limits to how much compliance can take place when it comes to uncomfortable yet protected speech. There needs to be other outlets, other mechanisms to address sticky situations, let's say, to call it that really are happening around uncomfortable speech. And so alternative methods of counseling students, certainly among students, we talk about restorative justice a lot, ways to resolve disagreements, upset feelings, even trauma that could occur from protected speech. There needs to be other outlets, other avenues within institutions to address these situations. And then finally, just at the individual level, I think that it's important for us to both improve our understanding of how to act when these situations arise, if we're present in those situations. And then really, as I'm speaking with a group of folks that engage in mediations and alternative dispute resolutions, you all are what I consider stewards of democracy, and and we want you to expand your influence and advocate for these alternative resolution solutions in different settings and in different spheres in society. And I think I'll just conclude by sort of dwelling on that for just a minute, which is that, again, we're at the anniversary of the January 6th attacks on the nation's capital. It's important for us to understand that we need to, coming back to this initial question, preserve a space, not only for conflict and disagreement, but for the successful resolution of conflict and disagreement. And my answer to this question of why it's so important is because we really need to cultivate a society and a citizenry where we can disagree with one another without resorting to violence. I mean, that's the basic minimum, right, of a democracy. But also that there is an opportunity arising from disagreement and conflict where we learn from people with different views from ourselves, where we learn from folks who are different in their identity and their background from ourselves. And that through that conversation, that exchange of ideas and information, this notion of diversity and pluralism can become cemented and can become a part of who we are, as a nation. And so, by way of conclusion, we need to preserve, to preserve a space where people can criticize and be with the freedom to say things that might not be correct, that they can criticize the government, they can criticize each other. In this way, freedom of expression is a part of what it really means to be human. It's a human right. And if there is no visible conflict, in a way, there might be order in our society, but there really is no freedom. And so it's more important than ever that we preserve this space, and also that we provide a way for there to be successful resolution of disagreement. Because if we don't facilitate the successful resolution of conflicts in an orderly way, I think that sows doubt that maybe there needs to be more order imposed, more authoritarianism, more fascism, more suppression of dissenting views. And this, that scenario is something that I think we can agree is not something that we want in our society. So that's, I think, sort of my message and my reflection to you all, speaking to this body, of why it's so important of the work that you do, is because you really do not only preserve a space for this conflict and disagreement, but you pave the way to show that we can resolve this disagreement in a way that's really, really important for all of us, especially reflecting on this day and this anniversary. So with that, I will stop and sort of open up the floor. Thank you.
I think we have a couple of questions on deck from the chat early on. So while everybody else kind of gathers their thoughts after such a great presentation, for live questions, we can pivot to ask you a couple that filtered in while you were speaking. The first is from Jess Kent, and it's a pretty big, broad question, but she asks, what is your canon for expertise that every conflict resolution specialist might want to read? You mentioned critical race theory, and Jess was wondering what additional suggestions you might have to ensure education of mediators worldwide.
Oh, canon. Oh my goodness.
It's a big question.
It is, I know. It's so funny. On critical race theory, I've been thinking a lot about it recently, just because it's something that has been in the news a lot and is affecting school systems so much in a way that I never anticipated how much it would. I thought that it would die down sort of after the initial, after early 2021, but it really took off, and there's over half the states in the United States. No, I take that back. About a dozen states or so have laws now that are banning some discussion of race or sex in schools. And over half the states have proposed legislation, including in New York, by the way, which hasn't gone anywhere yet in the legislature. But so that's an interesting sort of whole set of, discussion of law and speech related to critical race theory. In that area, I mean, I think it's important to, this is not answering the question at all, but I'm thinking of critical race theory, and I think it's useful to understand what that is, and to understand that these laws that are being passed around banning, sort of purportedly banning critical race theory, have nothing to do with actual critical race theory. But as I've been advising people in different trainings and presentations, I think it is worth understanding what critical race theory is, and that canon, so to speak, in order to be able to articulate to others that these laws are not about critical race theory. So there are a couple of readers and annotated books around critical race theory, written by Richard Delgado and Stefanich, and also written by Kim Crenshaw and one of my former professors, Neil Gotanda. So, I think they all have critical race theory in the title. So if you look up Delgado and Stefanich or Crenshaw around critical race theory, you'd sort of understand a little bit more about what that body of work is. Very important, actually, body of work that I think helps to critically analyze law in the United States, and to help us maybe get this insight into whether or not the US legal system has been effective or is properly equipped to reduce racial disparities in the United States. There's a lot of analysis and thought that maybe things don't work quite so well, and haven't worked quite so well in terms of securing racial justice in this country due to flaws in the U.S. legal system. So I think that that's a great place to start if you're interested in learning about that topic, for example, and also how law has developed in this country in ways that either do or do not advance rights.
Thank you. So before I jump to the next question, can you stop the screen sharing so that we can kind of bring everybody's screen back to the community of perfect. Wonderful. And I know that was a big question, and these are continuing conversations, and everybody should really feel free to continue on the dispute resolution listserv that Maria runs and through ACR-GNY. The next question that I wanted to pivot to is from Judy Cohen, and it's a two-parter, so compound question, warning. One, are lies, misleading statements, and disinformation acceptable under the principles of freedom of expression? And by disinformation, she means false information, which is actually intended to mislead. And what is the impact of these types of communication on democracy and on the free exchange of accurate information?
Yeah, I mean, I think that there's lots of lies and disinformation happening, and we all know that. That's clearly something that is, with the ever more pervasive influence of social media. We know that the spreading of lies and disinformation can have a dramatic impact on democracy. Again, we're talking on January 6, 2022. So fully appreciate that question. And legally, many of you, a lot of you are lawyers, so you know this. There's certain ways in which lies can become out of bounds or are not protected. In the area of defamation. Lies, in form of libel, slander, and those kinds of things. Those are not examples of protected speech. I won't go into that area of law too much, but certainly, you would want to demonstrate the falsity of information as part of establishing libel or slander, and then the more public the figure is, like for example, a U.S. president or something like that, the more that you have to really be speaking with some kind of malice, even beyond the falsity, for that to be not protected. So, but yeah, so there are some legal apparatuses that do protect against defamation, for example, but in other ways, people can lie and say things that are untrue. And a large part of that, especially if government, I guess we should start with this. I should have started saying that most speech is not regulated. Most speech is not subject to government oversight, and is conducted among private citizens or in the news or in the media and so forth. So very, very, very strong ability for people to spread lies and disinformation in a way that is not censorable or regulable in a large sense, but also is troubling and can have an impact on our democracy, as we have seen.
And how do you distinguish between lies and viewpoints?
You guys are asking such good questions.
We're a tough crowd.
Yeah, absolutely. I mean, this is, if I could have a magic wand to be able to do that, I think I would be making a lot more money than I'm doing right now. But I don't know. I think that is a very good question. We attorneys, we really sort of focus on facts and factual, and sort of trying to establish facts, and that's very important in bringing arguments in court, for example, and in convincing a judge or jury that these facts, according to these facts, that a certain argument or set of interests should prevail. But again, sort of the normal the normal world outside of courtrooms and legal proceedings are not so constrained, you know, and so what people articulate can be true or not true. And yeah, again, this is the tough thing about being in a messy democracy, is that that people have the right to lie. People have the right to, those lies can be express a viewpoint or you know, effectuate a viewpoint, but fact-based communication is not what we are limited to as a society. The price of democracy is that we do not always have to engage in fact-based discussion. And you know, this is also understanding that not every discussion is intended to be, should be fact-based. We think about art, the artistic world, and different ways of creatively expressing ourselves. That's not necessarily fact-based, you know, can delve into fantasy or alternate realities, and that's okay. So if we want that kind of different modes of expression, there has to be some tolerance for information that's not necessarily truthful or based in fact. I think we all know this, but yet we can still be disturbed by the you know, the bad effects, I think, of disinformation or lies as they affect how people behave, how they vote, you know, and how politicians act and so forth. So I'm appreciating the concern, but also one of the points here is that it's that there's a certain gray area that's for messy and suboptimal speech that we need to tolerate in some ways.
Yeah, speaking of that, I think that's a nice segue. I put in your Twitter feed at the beginning of the conversation, and you have a pretty robust and active, I think, string of communications there, and I encourage everybody to check them out. And subscribe. The next question we have is from a non-attorney participant, Ellen R., who is asking about protected characteristics and classes. And she notes that these are really changing in our culture. For example, transgender individuals were not a protected class until recently. And under different administrations, they could be disenfranchised again, along with many other groups. How, when things hinge on those kinds of characteristics that are protected, are these rights truly protected?
Yeah, I mean, I was involved in the Obama administration during the time of where the guidance around transgender students was being proliferated, you know, issued, and then that trans protective guidance was later rescinded by the Trump administration. But yeah, I mean, it's remarkable the development of sort of categories of protected classes that were not in our consciousness, you know, in even 10 years earlier before. I'm so, you know, I'm so mortified to recall that when I first started out as a LGBTQ rights, you know, working in LGBTQ rights in the mid-90s, I myself did not have a clear understanding of what who transgender folks were and what that meant, you know, and that, you know, that was something that I became much more educated on in subsequent years, or certainly after a little bit of doing that work. But, you know, going from that point to then working in the, you know, gosh, when was it now? It was about 8 or 9 years ago now, on the transgender rights, student rights issue. You know, we've come such a long way, and look how far the Supreme Court has come just to stay on that topic for a second, they didn't even want to say the word gay in before the mid-90s in any Supreme Court opinion, to going all the way to protecting not only people on the basis of employees on the basis of sexual orientation, but also gender identity in the Bostock case less than 2 years ago. I mean, it's just incredible, the progression. So these classes, new classes and new understandings of people and who needs to be protected is always evolving. And I think that's the beauty of our system. But at the same time, we know that classes that have existed for a long time continue to be underserved. So race has been around as a civil right in earnest for several decades now, and yet, we know that we're still not making significant progress in many areas when it comes to racial justice. So absolutely, yeah, the notion of protected class is something that is an interesting and wonderful part of the legal system, and yet it doesn't always alone, just by the identification of that class, create equality.
Great, thank you. I want to encourage anybody to jump in. I do not need to be the mediator of the voice of the questions, but we've just got a couple minutes left. We had another question from Harvey Newman, who asked about what your thoughts are on the fact that he observes that the media exposes the messiness of democracy to everybody. And do you have the impression that this is driving people to seek a seeming assuredness of authoritarianism? Or more broadly, maybe you can make some comments on your thoughts of the role of media in freedom of speech.
Yeah, I mean, what can be said? I think the media has always, I think, been potentially, clearly a free media that is untethered from government is one that is something that we need in democracies. All democracies need that, for the idea that the media can be independent and not be subject to censorship. So that has been clear for several decades. I think this is a conversation, so I'm reflecting things that we all know. I'm not saying anything that terribly insightful here, but it's just that the issue for me is that the media has become itself more polarized in serving particular constituencies, and also not as fact-based, let's say, in the presentation of certain ideas or information. And so when the media becomes disassociated from or represents itself as one way, giving information in one way, but is actually engaging in it presents itself as news-based, but then is engaging in sort of editorializing and sort of something that's going beyond sort of news. I think then the public can become influenced and misled in certain ways. And I think that's maybe one observation that we all, I think, have read about and are worried about, that I think is a product of our times. It's something that we have yet to catch up with, in terms of media and social media, what their influence is, and what permissible kinds of regulation there should or ought to be, given the way that the media has transformed in the last 15 to 20 years.
And with that, Bob, thank you so much for being part of this historic morning here with us. You've been informative, inspirational, and this was incredibly timely for us. So thank you once again for taking on a very hard topic and making it easy for us to all understand. Thank you, everyone, for coming. See you next month. The topic will be But's work. Batabile Umtambeni will be presenting. See you in February. And we're going to stop the recording now. Bob, if you have a minute or two to hang around, if anyone has any thoughts they would like to share or questions informally. I'm willing to keep the Zoom call open for a short while. Bob, do you have another few minutes to hang out?
Yeah, absolutely.
All right, I'm stopping the recording now. So we are now off the record.
Great.